opinion. Okay, so it is 5 o'clock with 4 minutes. So Bill, if you're okay with it, we will start.
That's fine. This is like extra time in a football game.
Exactly.
Yeah.
Okay, so this is the first round.
Right.
All right. So good afternoon, everybody. I welcome you to our monthly presentation. Today we have, and I have the honor to welcome our speaker, Bill Wingett, Bill Wingett, a partner of Wingett, Spadafora and Schwartzberg LLP in New York. Today we are going to speak about when does crime pay. We will have a general overview of crime insurance policies and fidelity bonds. If you allow me, I'm going to read Bill's short bio so I can introduce you, Bill. So Bill Wingett co-founded Wingett Spadafora Schwartzberg LLP in 1993. In a career spanning more than 3 decades, Bill's work has expanded to focus on a number of distinct practice areas that, despite their outward differences, routinely present common legal issues and analogous controversies that demand the same skills, experience, and insight from counsel. Bill's practice areas include professional liability defense of large businesses providing third-party administrator, computerized bill review and forensic investigation services, commercial and business litigation for corporate clients, particularly in dealing with successor liability, non-compete and fiduciary obligations, and M&A related contract disputes. Defense of architects, engineers, life insurance agents, attorneys, and other licensed professionals. The investigation, adjustment, and litigation of complex claims under crime insurance policies with increased focus on computer fraud coverage and losses attributed to unauthorized penetration of computer systems. Representation of surety companies and their principals in all phases of construction litigation and related negotiation. Representation of general contractors and building material suppliers in all phases of construction and products liability litigation, and directors and officers insurance coverage. Bill,
that's great. That's great. Is
this enough? Because I have more information on you.
Thank you so much, Zita. But you know, Bill Wingett from Wingett Spadafora Schwartzberg would have been fine, but thank you so much for doing my advertising for me.
Okay, whenever you wish. So the floor is yours if you want to start.
And please, and thank you everybody for coming. And as I always say, when I have the opportunity to work in Mexico, I always thank my colleagues in Mexico for speaking English with me. And I'll say that again. Appreciate it very much and appreciate the chance to be here. I thought I'd speak today about an insurance product that is increasingly something that my major corporate clients are involved with, but that many attorneys, even very sophisticated attorneys, and even attorneys that are very familiar with insurance coverage generally, do not have a lot of working knowledge with. And those are, as the title suggests, crime insurance policies or fidelity bonds. Historically, and what are they exactly? Well, fidelity bonds historically were issued to guarantee the faithful performance of a single employee. They were actually true surety bonds, whereby the issuer of the bond guaranteed the faithful performance of the employee, namely guaranteed to cover any losses caused by the employee. They were not actually insurance policies at all. They were actually surety bonds, which bear some similarities, but are really totally different than insurance policies. They've now, in the last 50 years or so, fidelity bonds have evolved into more conventional forms of insurance. They're standalone insurance policies with bundles of different coverages triggered by various events associated with criminal or dishonest conduct, both by employees and third parties. The term Fidelity Bonds is actually an anachronism, if that translates. It really is an outdated term since they are no longer surety bonds, but the name has stuck. So you will often hear crime insurance referred to as a fidelity bond, even though it's a conventional insurance policy, not something issued on an employee by employee basis. It's especially common to hear the term fidelity bonds used with regard to banks and financial firms. Recently, just the way the insurance industry is working, I've been doing this kind of work, among other things, for 35 years. When I started, fidelity and surety was a very specialized area of insurance, and fidelity coverage and crime coverage was always issued on a standalone basis by companies that oftentimes didn't do any other kind of work, or at least by a division of a company that didn't do any other kind of work. In the last 5 or 10 years, crime coverage and fidelity coverage have been bundled with packages of liability insurance, like directors and officers, cyber liability, professional liability, and general liability packages. That said, it creates an interesting situation because as I very often run into very sophisticated in-house lawyers, very sophisticated private practice lawyers who are very familiar with how liability insurance coverage works, but who don't necessarily have any real working understanding of fidelity coverage or crime coverage, which is a totally different animal. And as something that I hope will interest those of you who've joined us today, I'm also increasingly getting cases. I represent both insurance companies for purposes of investigating claims and actually being the insurance company's representative, but I also represent insureds when I'm not conflicted out. And interestingly, in the last 3 or 4 or 5 years or 6 years, I'm getting an increasing number of assignments on cases involving companies whose primary business is in Latin America, but who have an American affiliate and decide to purchase their insurance through their American affiliate, which means even for their operations in South America or Mexico or Central America. And that creates this kind of interesting situation. And by the way, there's very complex tax and international business concerns for that I won't necessarily get into, but it creates an interesting situation where more and more I am dealing with companies in Latin America whose primary businesses in Latin America, where the senior executives are based in Latin America, but they have purchased their insurance through an American affiliate, meaning their insurance claims need to be handled in compliance with American law, with US law. And that creates what for me is an interesting, cross-border situation. So that for some of you, if you're practicing in Mexico, you may well, and again, I know I've worked with Zita's firm that's been good enough to assist me on several of these. You may very possibly have to encounter American insurance laws and American insurance policies for businesses that are primarily in Latin America. The first thing to talk about a crime policy, to distinguish it from the kind of most insurance coverage that a business lawyer is going to deal with, is liability coverage. If the directors and officers of a company get sued, they want insurance to protect them, to provide for defense costs, to cover them for their liability. Crime insurance is a different animal. It's what we call first-party coverage, meaning it basically doesn't have, and again, I have to qualify that, but in essence, in its most simplistic form, it has nothing to do with liability to third parties. It deals with losses that are incurred directly by the insured company. So it's not a liability insurance product at all, although there are plenty of situations where the boundary between liability insurance and first party insurance is blurred. So, and again, Fidelity policies provide a bundle of different kinds of coverage for problems that associate with what we think of as criminal conduct. The most commonly, so there are a package of different insuring agreements. The most commonly invoked insuring agreement that surfaces is for employee dishonesty or employee theft. And that's if, you know, I mean, in its most common form, the controller of the company figures out how to transfer $6 million in increments usually to an offshore account, and it doesn't get discovered for years. And when it does, the insured company realizes that they're out hundreds of thousands or millions of dollars. But these policies, so employee dishonesty, and for that, a claim gets submitted saying, hey, you know, John Smith has stolen $5 million from us, and we want our insurance to pay for that theft. By definition, you know, controllers and accountants don't leave a clear trail. They try to cover their tracks. So proving the loss is usually a fairly complex objective that requires forensic accounting. The other kinds of coverage that are available involve losses due to forged signatures, and an increasingly important one is computer fraud coverage. A common coverage issue that comes up a lot in terms of these policies, and again, I'm getting technical, but it's if you ever do get a claim involving this kind of situation, it's important to know that. Very often, an employee of an insured company, especially financial firms or brokerage firms, steals money not from the insured itself, but from a client, or does something dishonest that the client believes have resulted in a fraud. And many companies automatically assume that their crime insurance protects that. But if you think about that, that is not a first-party loss actually incurred by the insured company itself, even though it's caused by the insured company's employee. It's a loss incurred by a third party. So that kind of situation, unless you negotiate for additional policy language, is generally not covered under the policy. And if you're advising a corporation or working with a corporation, it's important that they understand that, so that if they have employees that have contact with or access to a client's money or assets, it's important to know that your crime coverage doesn't kick in unless you negotiate a coverage enhancement that says not only will we pay our insured for losses, but we will pay our insured for client losses that are incurred due to the employee's misconduct. And again, I'm going through a technical discussion of one of the cases right now that will be online in case you want citations to American cases. I included Texas, and I know my Mexican friends deal all over the United States, but it seems like Texas and Florida and New York are the most commonly encountered states that you all work with. So I've tried to include Texas and Florida and New York cases here as examples. And as I say, this slide here, I make a big point of saying, if you're ever advising a business on their coverage, if they're an accounting firm, if they're a nursing home, if they have access to client assets, which can happen in all kinds of different situations, they need to get, if there's a possibility that their employee is going to steal from a client, they need to get what we call client property coverage added to the policy, which makes the policy a little bit more like a liability policy in that it potentially provides coverage not for the insured itself, but for a third party that arguably was victimized by the insured. the other thing that's important to note about crime insurance is the policies have been, the standard language in the policies has undergone huge changes in recent years. So if you're ever researching American law on the meaning of these policies, make sure you bring it up to date because there's been a lot of changes in the policies. So again, let's look generally at what is covered. And again, this is kind of heavy going, and I appreciate you're all following me so far. I would just mention, if you have any questions, please don't hesitate to ask. And I forgot to point out at the beginning, as we have to say in all of these presentations, I'm not purporting to give you legal advice or a legal opinion here, and you shouldn't be relying on this directly for legal work. You need to verify everything I say in here. But in any event, let's look a little bit more specifically at what is covered under a crime policy. And again, I'm now advising 2 global companies where the general counsels, very sophisticated guys who worked with other kinds of insurance regularly, had a major loss occasioned by employee dishonesty, in one, very sophisticated employee dishonesty. And they, despite being super bright guys, they basically didn't have any idea how to pursue their crime coverage or what was covered. And in one case, they neglected putting in a claim entirely. And in another, they didn't put in the claim properly. And in both cases, my firm is now trying to fix the problem in both situations. But the clients have a lot more stress than they ever bargained for, when if they'd really had any kind of even a vague familiarity with how these policies work, it would have saved them a lot of grief and heartache. So I'm hoping that some of this will stick in your mind in case it comes up. Crime isn't something that happens at the white collar level that frequently. So these are usually not issues that you need to understand or work with every day of the week, unless you're actually working directly for insurance companies. But when it does come up, it becomes obviously incredibly important. So again, as I said before, what is covered under a crime policy? There are a kind of bundle of different coverages. Employee theft coverage or employee dishonesty coverage generates the greatest volume of claims. And as you can see from the thing, it basically, if an employee commits theft, either on his own or in collusion with others, the insurance company will pay for the loss. And again, to get a little technical with you, what is the definition of theft? It's a very broad definition in most policies. It means the unlawful taking of property to the deprivation of the insured. So that can mean a huge, if you think of all the infinite number of ways people can be dishonest. And as I was just saying with Zita, we get cases involving shipping managers that figure out how to steal truckloads of commodities on a regular basis and sell them in what amounts to a black market. We get, controllers of companies who figure out how to transfer money and disguise it as some kind of a requisition payment. There's no limit to the kind of dishonesty that can surface. And the definition of theft in modern policies is fairly broad, although it doesn't take in everything. We often get, when I'm working for insurance companies, we often get cases where a business deal blows up on an insured, say a bank, a loan goes bad, and the insured will attempt to seek coverage based on the theory that the loan officer exaggerated the quality of the loan or did something dishonest as regards to the quality of the loan. There are usually exclusions that will take that out of coverage, but nonetheless, there is, if you ever have a loss that involves employee dishonesty, there is potentially a pretty broad scope of coverage under these policies out there.
Bill, I have a question.
Please.
Carlos. Yeah, I have seen many cases like the ones that you are describing, where, like you said, an employee is little by little, turning some money out of the company, out of the company's bank account into his own or a third party's, but ultimately it comes out. So for me, the challenge has been basically to prove the event. And my question is, um, what is the expectation when you need when you want to collect a bond like the ones that you are describing? You need to get a prosecutor to confirm that was actually there was a crime or a conviction, or is it sufficient for you to provide the evidence by yourself?
Some great question. Some crime policies require the insured to report the dishonest conduct, assuming it's an employee theft claim. And they do that because they feel that that is it's a kind of safeguard for them that the insured is not submitting a fraudulent claim, but they don't require successful prosecution. At least in the United States, we have a higher standard of getting a criminal conviction than we have of establishing civil liability. So, as our criminal standard to convict somebody of a crime is there has to be proof beyond a reasonable doubt. And I'm guessing that might be the case in Mexico as well, although Carlos, I'm always glad I have you and Zita so that I don't have to think about Mexican. I don't have to reinvent the wheel in Mexico. But our civil standard of liability is a preponderance of the evidence, meaning if, the evidence is 51% likely to favor the existence of a fraud, that's enough to show a fraud. So that's a much lower bar. And and there's no correlation required between the criminal prosecution. Although, again, when we're investigating, if there is a criminal investigation, it helps us verify if the prosecutors will speak with us. It helps us verify what the insured says is happening.
Okay, thank you.
And just to move through the menu of covered losses, some of which are becoming, in this day and age, like when I started my career in 1986, even large sophisticated companies wrote checks to pay their bills and to transfer funds and all of that kind of thing. It seems like now checks are almost becoming the way of the dinosaurs, and wire transfers and ACH transfers seem a lot more common. But again, forgery or alteration coverage, which protects insurance or the insured company from accepting a check with a forged signature or acting on a forged instrument, is another standard insuring agreement included in almost all crime policies. By the way, one thing that's important to note, if the loss is linked to an employee, the policies will have language that says if an employee is involved, the only coverage that we provide is under our employee dishonesty agreement. So the forgery or alteration coverage only comes into play when somebody outside the company is the perpetrator. And again, I added some more detail about the languages in there in case you want to check this. The key concept with forgery, and we do get even today a fair number of forgery claims. It has to entail the signing of another person's name with no authority and with the intent to deceive. It is not signing your own name without authorization, and it's not signing somebody else's name who you normally are authorized to sign under situations where you're not allowed. So if we oftentimes, when I'm representing insurers, will get a claim saying, we want forgery or alteration coverage because we got from an independent contractor, we got an expense report signed and it wasn't authorized and somebody paid it by mistake. that isn't forgery coverage because the person is signing their own name, even if it was authorized, even if it wasn't authorized. There's another insurance agreement, and I won't spend, these are pretty complicated policies, which is why, I hope you take away the message that if you have any kind of a loss and you're advising a business that involves any kind of criminal conduct, either inside or outside the company, you need to look closely at your crime policy. Companies, you may well have one, even if, we get companies that are 50 years old that have never had a single crime claim. And when they actually have a loss due to crime, they're not even aware that they've been paying premiums for 50 years to have a crime policy in place. So there's also something called inside the premises coverage. And that basically applies to whether if you have a burglary or a robbery, it's not a blank check, it's under certain circumstances. But again, what I'd like you to take away is just any kind of loss at a company that's associated with criminal activity is potentially covered under these policies. Although again, they're not unlimited, they're not blank checks.
Sorry, Bill, I will have to interrupt you again with a question. Sorry if I'm bothering you here, but no, a very quick question. To what extent the fact that there was an improper control from the insured will limit the payment, the contributory negligence, or I don't know how to call it.
Contributory negligence, that's a good point, is not a defense to coverage unless, and it's a big unless the insured misrepresents internal procedures in the application. I mean, you buy this coverage. I mean, I've handled claims from Fortune 50 companies, meaning companies that are among the 50 largest in the world. And the amount of screws, for want of a more sophisticated word, the extent of like supervisory screw ups are mind boggling. I mean, somebody gets comfortable with their bookkeeper, stops checking, and the bookkeeper registers a company with the name that sounds like a vendor that does a lot of work for the company. And, for 15 years, they send millions of dollars to themselves.
I have seen something like that, actually.
What's that?
I have seen something like that, actually. Yes.
Yeah. And, but that is why you're buying the insurance. You buy the insurance because you're recognizing that nobody's perfect. So contributory negligence has nothing to do with the extent of coverage, with one big exception, and that is when you apply for coverage, the insurance company will probably ask you about your internal accounting procedures in a very specific way. So if the insurance company's application says, do you require 2 sign-offs on every wire transfer over $1,000? And you say yes, and you then have a loss because you only have once, because some executive is able to wire transfer money to a confederate or to him or herself, that is going to create a problem. But it's not so much contributory negligence, it's just that you've falsified the application. And again, I'm oversimplifying. It's not that easy for an insurance company to get out from under its obligations, but potentially, if there's inaccurate information in a policy, depending on the state that you're in, you potentially have the grounds to take back the entire policy, which we use the word rescind the policy. I don't know if that's a word that you're all familiar with.
It makes sense.
And again, I Carlos, and you're aware of this because of, you've helped me out, but this is more and more significant from what I can see, because more and more businesses that have, especially businesses with large manufacturing facilities in Mexico and other parts of Latin America, are buying their insurance through a much smaller American affiliate, and American law is going to control on that. So it creates an interesting situation. And, Carlos, we've had fun dealing with that.
Yes.
Not just in Mexico, in other countries in South America. But it's the American law as to the impact of inaccurate information in a policy is potentially very significant. One thing that you all need to know, and obviously I don't want to get into too much detail. We're almost are we 50 minutes? Are we an hour, Zita? Are
As
we
you
40
wish.
minutes?
As you wish. I mean, and I invite the other attendees to make comments, remarks, or questions because it's really practical. So you still have time.
Okay. One of the issues in what's important to note in the United States is insurance is not federally regulated. So in fact, there's a statute, a federal statute, the McCarran-Ferguson Act, which explicitly delegates the authority to regulate insurance to each state. So it's a like securities in America. If you're all do banking and securities work, that is something with a heavy federal unified set of laws. There are also state laws, but for insurance issues, if you have a client with an insurance policy in South Carolina or Texas who has a loss in Colombia or Monterey or Chile, you need to look to the law of the state where the American affiliate is based, where the policy is delivered. There's no national American law on that. You need to look into the law of the particular state.
Okay, so there is a question, William, Bill, to that last point. So how should we select the insurance company or the policy or the policy to know what law will be the governing law to our case?
Well, it's not so much a question of the policy, it's whatever office or whatever location you choose to designate as your main office for purposes of the insurance. And I mean, there's reasons that companies whose primary operations are in Latin America nonetheless prefer to have their head office designated as being in the United States somewhere, even though they're essentially not primarily involved in the United States. And I mean, it obviously has to do with tariffs and labor policies and a variety of different issues. You probably know Zita and Carlos far better than I do. But
in your experience, is there any preferable venue, or I don't know, New York? Or...
Well, no, because I mean, I think New York is probably. I mean, no, I don't think companies set their businesses up to take advantage of the best possible insurance laws. I mean, there are some states that are known as sort of easier, that are better for insurance companies, and some states that are known as better for insureds. It's very hard to generalize about that, though. And it would be a very difficult thing to make a judgment call about what state is the best place. I mean, generally speaking, there'll be a reason for a company to set up their American affiliate in a particular state. And if they decide it's advantageous to buy their coverage through and list that American affiliate as their head office for coverage purposes, that's the state law that'll apply. But it's very hard to generalize as to what state is more or less, there can be unbelievably complicated technical issues with insurance, especially crime insurance.
Thanks.
And again, just to finish, I mean, the insurers have a menu of literally dozens and dozens of different insuring agreements designed to protect insureds based on whatever their business model is. You can see here this money order and counterfeit currency fraud. So, computer fraud is now becoming more and more important, and that's generated a lot of litigation. And I can tell you now, I've seen shockingly large losses involving computer hacking and deceiving insureds by the use of the computer. And the law is actually pretty unsettled on what's covered on that. And again, remember, this is first party coverage. So the kind of scenario you'll get is an email will come into the insured saying, hey, like you pay our bills every month by wire transferring our invoice payments to an account in Scotland. Gee, we want you to change that to a bank in Shanghai. And I'm not saying that to be like insult your intelligence. I've literally had cases that track this kind of fact pattern. And since they look very real and the fraudsters are able to disguise the emails to make it appear as they're coming from a very familiar address, and since they oftentimes monitor emails and are able to drop in that kind of scenario, causes huge losses. And I even stay awake at night for my own law firm worrying about this kind of thing. I mean, we've settled a case and we're waiting for the plaintiff to tell us the information for making a settlement payment. And the way these frauds work, they will literally drop into an email exchange, cut off the legitimate counterparty to the email exchange, and misdirect the payment of funds. And it's really shockingly effective to do this. Even very sophisticated, very careful people, when you're expecting an email with payment instructions and it comes in looking like it's from exactly who you're expecting it from, but it's directing it to an unauthorized account, there's a lot of room for people being taken in by that. And so the bottom line is computer-related fraud is becoming an increasingly significant area of coverage. The companies, by the way, limit it to a great extent, and the actual coverage is becoming more and more complicated. The insurers will essentially say that the original intention behind computer fraud coverage was that if somebody just hacked into your system outright and was able to transfer money from your bank account to a third party by hacking, they'll say that's what was intended to be covered. What's happened, though, is that since computers are used so universally for everything, issues come up as like, well, is a fraudulent email the same as hacking into my computer? So it's a very complex area of the law. There's incredibly complicated policy language. The insurers basically, and I mean, I don't speak for the insurers, but I think it's fair to say the insurers didn't intend to cover insureds to the extent an email gets sent with false payment instructions. And there's all kinds of language that says that the insurers will say that their primary intent was to provide coverage to the extent somebody hacks in to your computer system and successfully manages to, on a purely cyber level, convince your bank to transfer your funds out of your bank account or to otherwise directly cause you a loss. They would say, no, just like, we don't provide coverage for somebody using a telephone to commit a fraud just because a telephone was involved. Just because an email communication from an imposter was received, we don't cover. However, courts have not necessarily always agreed with that. So the extent to which fidelity policies provide coverage for computer-related fraud is a rapidly evolving area of the law. And again, if you have a client that gets defrauded via the use of a computer, you do want to look at your crime policy. It's not necessarily going to be covered, but it may be. So, and again, my objective today is not to educate you on the intricacies, which are many, but you do need to understand that there is this computer fraud coverage out there, and that it is a very dangerous part of our business world these days. Most companies, most policies, by the way, now require you to represent that you have to verify emailed payment instructions with a voice contact that you're familiar with. So in other words, there's just so many examples of this devilishly effective fraud where fraudsters are able to send somebody an email who's expecting instructions on payment, and with, you know, telling them, and they look shockingly real. So now most of the policies, or many of the policies, say we won't cover that unless you have independently contacted the payee and verified in a voice telephone call that the instructions you've gotten by email are in fact the instructions. So, and I know it, like you can, I know I find myself not even doing this. So again, it's a for me, a frightening area of the law. But it's important to know that most businesses maintain crime coverage, at least in America, they do. You know, the insurance brokers will convince almost all businesses that they have to have crime coverage. And in some cases, by the way, it's required by law. Securities firms, broker dealers, banks are actually required to maintain this kind of coverage. And it's important to know that there's at least a possibility that computer fraud coverage is available. Let's see, do I still have you? Okay, here we go. Sorry about that. I've got a flurry of emails that were coming across my.
I have a chat. I don't know. I have a question.
Okay.
Let me just. Priscila.
Sí.
¿Puedes atender esta chat, por favor, que nos mandaron? Sorry, Bill, I think it's not a question for you. It's just a general observation, but not regarding your presentation.
Unless it's saying, tell that guy to shut up. He's
No,
driving.
not at all, not at all.
So let me try in a very broad, but so again, I'm trying to give you the idea that these crime policies potentially provide coverage for a broad menu of coverage, and they have very specialized. I mean, there's coverages if you're in a real estate business. There's an insuring agreement that you can negotiate for fraudulent mortgages. There are insuring agreements for, you know, data processing fraud. There is a huge menu of insuring agreements, and it's not important that you know the nuances of every one, but it's just important to know, again, if you have a client or if you're an in-house attorney with a company that has a loss that's somehow associated with criminal conduct or dishonest conduct or fraud, either from internally from an employee or externally, one of the first things you want to do is, in addition to figuring out what happened, is find out if you have a crime insurance policy and give your crime insurance policy a careful read. Now, let me just give you a very broad brush look at some significant policy terms before we finish up, or I turn over the floor for questions. I wouldn't expect a lot of questions in a kind of new area on this, but what triggers the coverage? You know, you have a policy that's in place from January 1st, 2020 to January 1st, 2021. What is it that triggers the availability of coverage? Is it the actual loss? And the answer to this under most Fidelity policies is the more important date is the date that the loss is discovered. Very often these kind of losses are incurred in literally weeks or months or years that extend back into prior policies. So in almost all Fidelity policies or crime policies, the loss has to be discovered during the policy period. Now, some policies are even more complicated than that. Some policies say, and this is language that the insureds prefer, if you discover it during the policy period, we don't care when the actual loss occurred. Other policies say if you discover it during the policy period, we'll cover the loss during that policy period, and we'll cover it during prior policy periods, but only to the extent you continuously maintained coverage during those prior policy periods. So very often, and again, this is the kind of thing that when it comes up, it's a huge headache for an in-house attorney. You find that your controller or somebody in your accounts receivable or accounts payable has figured out how to slowly and steadily steal money every month for years. You then need to not only pull out your current policy, you need to go back and make sure that you've had continuous prior coverage throughout the period of the theft. But it's not something that's just, you know, we're used to what, you know, either claims made coverage, which is triggered when the actual claim is made for liability policies, or occurrence policies, which is when the actual loss takes place. But with Fidelity Insurance, it's discovery of the loss in some policies, and then in other policies, it's discovery plus the loss had to have occurred during a period when you maintained coverage. Let's go through just real quickly, and again, I don't want to go much past 655. What do you do if you're advising a business that has a loss that may be a crime loss? How do you actually get coverage under these policies? And this is where people often stumble. And I'll summarize very quickly. When you first learn you have a problem, it's very rare that the insured company will know the full extent of a loss. Criminals do their best to cover their tracks. And they very often will conceal bookkeeping entries, and it could be weeks or months before the insured fully understands the full scope of their loss. So what does the policy require? Essentially, when the insured discovers the possibility of a loss, if they uncover one fraud, even if it's for $25, and they say, oh my God, how do we know this guy hasn't been putting in fake expense reports for the last 30 years? At that point, they have an obligation to provide notice of loss to the carrier. And that usually has to be done as soon as possible or within a relatively short period of time. That doesn't require you to document the amount of the claim. It just requires a brief description of what you think's going on. And typically, the policies will have language then, in almost all cases, says, okay, after you notify us, within 6 months of the date of discovery, you have to provide us with a detailed proof of loss showing full particulars of the loss. And that is oftentimes a very complicated prospect. But again, as we're all lawyers, it's an evidentiary question. How do you prove a loss caused by a dishonest employee or caused by an outsider due to fraud? And just think, well, what would be the evidence required, say, in a criminal prosecution? Even though the standard might be higher in a criminal prosecution, you become, if you're representing an insured, you become in effect like a prosecutor that has to provide documents to an insurance company that essentially proves the amount of your loss and that the circumstances of the loss fall within an insurance agreement. Like, hey, we paid something based on a forged signature. Hey, an employee stole money from us. Hey, we got this email telling us to send invoice payments to a company that we pay millions of dollars to every month, and it was phony. And somehow we've paid bills to this company for the last 8 months to the tune of $4 million to the wrong account. And the fraudsters managed to not only trick us into sending the money to the wrong place, they managed to block the accounts payable notifications from the vendor that was servicing our oil rigs, that kind of thing. So, and again, the details of this are a little bit too much. The important thing is to understand, if you're you've got to notify the loss as soon as possible, and you then have to provide a detailed proof of loss, usually within 6 months of the date of discovery. It's important to note, not from the date of the actual notice. People often maintain they often make this mistake. They will notify the loss 40 days after they discover it, and that might be timely. And then they say, okay, I have 6 months from the date I provided the notice to provide the proof of loss. And in fact, the time for providing the proof of loss is measured from the date of discovery in almost all policies, not from the date of notice. And again, it's hard to envision this as we're sitting here and relaxed. But if you actually have a loss, I know people that have, had heart attacks practically from realizing that they were miscalculating the time deadline for filing a proof of loss. Now, I don't know about Mexico. In some American states, remember, you have to look at the law of every state. Some states don't like insurers to decline coverage for not meeting a deadline. And they basically say in some states, we're not going to void insurance coverage for late notice or late proof of loss unless somehow the lateness prejudiced the insurer. I don't know. Do you have the concept of prejudice in Mexican law in this context? But it's not the case in every state. And, some states say, well, you know what? If somebody's late with their notice, we'll give them a break unless their insurance company can prove prejudice. But if they're late with the proof of loss, sorry, we're not going to impose a prejudice requirement for that. So you still, even though some states won't allow insurers to strictly enforce time deadlines, other states will. So you have to be very careful. And as I said, the one thing, if you're dealing with an American insurance policy, even if it's an American insurance policy issued to a company who has an American office but does most of their business in Latin America, and even if the loss is incurred in Latin America, you need to work within the parameters of American law of the state that the company was based in. So, and I give you some examples of how it plays out in different states, New Jersey, Texas. And again, I don't want to impose on everybody. So when you get a claim, and I'll just finish up with this, you've got to provide notice to the carrier, the insurer. You have to then provide a detailed proof of loss, which takes a lot of work. Pay attention to the time deadlines and measure deadlines from the date the loss is discovered, not the date you chose to notify the carrier. Keep in mind as well that insurance companies realize how difficult it is to document a crime claim, and it's expected that extensions of time will be requested. If an extension is requested in advance of the deadline expiring, the carriers will usually grant it. But make sure, of course, that that's in writing. And again, don't mess around with the deadlines for filing a proof of loss. Once you file a proof of loss, and Carlos, you've helped me with this, and I'll finish real quickly. The carrier then investigates. The carrier isn't just going to say, okay, you've told me you lost $3 million because of this complex fraud where the head of your shipping department figures out a way to send a truckload of raw materials every month to be sold on the black market and to conceal the paper trail. Then the carrier is going to go out and investigate. He's going to demand, if it involves an employee, the personnel files. There's a whole host of complicated investigatory procedures that go through. So if you have a claim in Mexico, it's good to call somebody like Carlos who understands how this works. If it involves an American policy, it probably wouldn't hurt to call an American law firm that specializes in this kind of thing, because you can run into a lot of trouble with this. So that's my kind of broad brush, and you can see in my PowerPoint, what's the insurer trying to figure out? Is there an innocent explanation for the alleged loss? If there's an employee involved, I'm going to make sure to verify that this person was an employee when he was supposed to. I'm going to make sure that the loss was discovered after the insurance was actually purchased, not that the insured became aware there was a loss and then went out and bought coverage. So it's, again, these are big, complex projects. Sophisticated lawyers might only encounter one or two of these in their entire career, if any, but just knowing that this is a whole unique area of the law, and no matter how good of a lawyer you are, you can't rely on your own experience if you haven't dealt with this. It's very important to realize These policies are unique animals. And I think I'll probably have thrown far more information at you all than you can possibly have absorbed. I'm happy to answer any questions if there are any, although, if you're even awake, I'll be very grateful at this point.
We're super awake, Bill. Thank you very much. And I really appreciate for your time and for your broad experience you're sharing with us. I had a message from Jaime Rodriguez, who is an important executive of one of the big corporation here in Monterrey, thank you very much for the conference. It has been very interesting. I have to attend the meeting at 6. So he apologizes. He had to leave, but he's very much appreciating. I don't know whether there is any questions or comments on the above of the subject matter. Anyone with experience with the execution of these policies?
Well, I do have a question, Bill. I know that you talked about more, given the name of the concept, it's fidelity, which associates to employees. But I was wondering whether, and I assume there are, but if you could briefly explain how a company could be protected against cyber attacks, because I know that this is a problem that is growing every time more. Hackers and even ransomware and things like that.
Right. And again, you have to, the different kinds of criminal activity involving computers has become unbelievably broad, as you know. And the kind of protection that you need is unbelievably broad. Crime policies potentially protect you. And again, I'm oversimplifying, to the extent hackers manage to hack into your system and literally steal money from you. And again, I'm really oversimplifying on this. To the extent hackers are able to successfully orchestrate a transfer of assets from a company. There's a whole nother category, though, of losses and problems for businesses involving cyber, which is when hackers get into the confidential protected information of clients and therefore expose the insured corporation to violations for failing to protect confidential client information. That kind of scenario is generally not covered under crime policies. That is, again, remember we talked about first-party coverage that deals with a loss directly incurred by an insured itself, as opposed to liability coverage that deals with what happens when there's claims against an insured. A major part of cyber coverage, I mean, certainly a major part of protecting yourself from cyber-related problems is the crime insurance policy and the possibility that somebody will liberate money from you by deceptive, hacking into your system. But the other problem is that you will be potentially violating your obligation to protect client confidential information and be confronted with a nightmare that requires you to hire forensic computer scientists to try to analyze what's been taken and to investigate what's been taken. You then have to do mailings, and those are usually separate standalone policies that provide cyber coverage. However, more and more now, cyber coverage, which used to be we think of as a separate policy, is being bundled. The brokers for the major corporations in the world are increasingly deciding that insurance is best sold bundling the different types into a single package, that the risk manager of corporations find it easier to deal with that. So along with a crime insurance policy, you would also be looking for a cyber policy, which says, okay, if somebody gets access to the, like Home Depot had a huge loss involving people getting into the system and accessing, credit card information and potentially endangering all of, thousands and thousands of customers.
Yes.
The insurance in that case, what does that cover? And potentially provides coverage for the cost of the investigation, for the cost of what they call remediation, and for notifying the victimized customers. That's a whole different problem that needs to be kind of addressed and coordinated with crime coverage.
Thank you very much, Bill.
Bill, I
And
get
again,
another, I get another message from Beatrice. She's asking whether you were able to share the presentation. Can we share your presentation with the attendees?
I'm happy. Yeah, you can. Yeah, the PowerPoint.
Yes.
Yes.
Okay. And you have your contact info on the PowerPoint, right?
I'm a terrible marketer. I don't think yeah, I guess we do. Yes, we do.
Okay.
Yes, we have we do. You're right. Sorry about that. I'm not a terrible marketer, but, and again, thanks everybody for listening. Again, this is all I'm trying to get across is just how kind of unique this area of the law is. And if you do stumble into this, if you have a client with a financial loss that's associated with, being defrauded through the computer, some kind of criminal activity, I'm not saying it's always going to be covered, but you need to look at the crime insurance policy as one of the first things you do, and make sure you find out when notice is required and when proof of loss is required.
Thank you. Anyone, a last question?
And again, thanks for everybody's patience. And this is the kind of thing where I know if I was an in-house lawyer with all kinds of complex problems, probably the last thing I'd be worried about is what happens if, my accountant steals money from me. But it's, again, maybe never, but if it does come up, it suddenly becomes a high stress generating problem.
Okay, I have your last question is, how long does it usually take to reimburse the company for the losses after the legal process?
That's a great question. It's not that fast, because remember, there's a notification requirement that basically is, as soon as you find out, have reason to think you've been defrauded, you have to notify the carrier. But then you have to provide proof of loss, which, again, proving a financial loss due to criminal activity, sometimes it can be easy, but other times it can be very difficult. And it can take a lot of forensic accounting work. So oftentimes, I've had many cases where the insureds have requested extension on the time for filing a proof of loss, and it goes for a year, even more. But then when the proof of loss is provided, the carrier is entitled to investigate. So it can be something that takes literally years to play out.
Thank you, Bill.
Thank you, guys. And again, thanks. And it's always great to talk to you and Carlos and Zita. Thanks again, guys.
Thank you very much, Bill. I'm going to share your presentation with everyone who attended our chat. Our program today. And any questions? Everybody can directly address to you. And I'm so happy we had you here today.
Thanks. Very nice. Be well, everybody. Stay safe with all these variants I'm reading about.
Thank you very much, Bill, again.
Cheers.
Thank you. Bye.
Bye.